Now we are going to discuss delay and laches in filing a writ petition before High Court or Supreme Court. Dear students, under Article 226, the power of High Court to issue a writ is discretionary. Discretionary से क्या मुराद है? Discretionary से मुराद है optional. The relief cannot be claimed as of right. However, where the relief claimed is one relating to enforcement of fundamental right, the court must grant it. Dear students, one of the grounds for refusing the relief is that the petitioner is guilty of delay and laches. If the petitioner intends to take relief, it is imperative that he would come to the court at the earliest reasonable opportunity. अगर कोई aggrieved है और वो रिट पिटीशन फाइल करना चाहता है तो ये उसके ऊपर इनकम्बेंट है कि वो विदाउट एनी डिले एंड लैचेस जो है वो कोर्ट ऑफ लॉ से रजू करे. लफ्ज जो रीजनेबल है इसका मीनिंग है लॉजिकल, सेंसिबल. डियर स्टूडेंट्स, inordinate delays in filing the writ will be a sufficient ground for refusing to exercise the discretion. Inordinate delays से क्या मुराद है? इससे मुराद है undue delay. अगर एक शख्स ने रिट पिटीशन फाइल करने में किया है तो हाई कोर्ट उसको डिनाई कर सकती है कि वो उसकी पिटीशन को एंटरटेन नहीं करेगी. Dear students, it is essential that the aggrieved person who is aggrieved of an action of government or any executive action should come to High Court with utmost expedition. Dear students, in an appropriate case, the High Court may not exercise its discretion and may refuse to grant relief if there is such negligence or omission on the part of the applicant to assert his right as taken in conjunction with the lapse of time and other circumstances. As a general rule, the superior courts are averse to granting relief in the exercise of their extraordinary power of judicial review to parties who are guilty of laches or delays in invoking the jurisdiction. The reason being that by their omission to act promptly, such parties may be deemed to have accepted the orders of the administrative authorities, and it would be unfair to disturb at their instance rights and obligations which had been settled and finalized long ago under the relevant law. My dear students, difficulty arises as to measures of delay since the Limitation Act 1908 does not apply to writ petitions and no period of limitation is prescribed by the Constitution of Pakistan 1973 to move the Supreme Court and High Court. The matter is more or less left to the judicial discretion. Dear students, in a case, it was held that no hard and fast rule can be laid down as to when the High Court should refuse to exercise its jurisdiction in favor of a party who moves it after considerable delay and is otherwise guilty of laches. That is a matter which must be left to the discretion of the High Court, and like all matters left to the discretion of the court in this matter, to discretion must be exercised judicially and reasonably. My dear students, रिट फाइलिंग के ऊपर जो लिमिटेशन का टाइम है वो लिमिटेशन एक्ट 1908 से रेगुलेट नहीं होता, बल्कि ये डिस्क्रेशन ऑफ द कोर्ट है और डिस्क्रेशन ऑफ द कोर्ट को इस्तेमाल करते हुए जो कोर्ट है वो रीजनेबलनेस को मलहूज़े खातिर रखेगी.